For those of you who don't know me, I'm Judge Tom Harmon. I've been on the bench for 14 years. I bring kind of a unique perspective to this panel this afternoon. Before I went to the bench, I practiced law in Douglas County and probably throughout the state of Nebraska for 26 years. So this afternoon, I bring a perspective of both as a judge and as a practitioner in most courts. You know, I think the most difficult thing for me was practicing for 26 years. The difficult thing for me is to watch trials and not participate, to become the arbiter, if you will, the referee, the individual who's calling balls and strikes. One of the things that I wrote down in the first day that I went to the Judicial College, one of the judges that was teaching us gave me a little poem, and I keep it in one of my books. And this is what the poem says. Now I sit me down to judge. I pray the Lord I shall not budge from my resolve to shut my face and let the lawyers try the case. And that's kind of my proviso. I've seen good lawyering and I've seen bad lawyering. And I think the greatest difficulty for me, especially for the young lawyers that are in the room today, it's very difficult to get out of law school and to think that you know everything there is to practicing law. You don't. You learn practicing law after a lot of hard knocks, talking with people, understanding people. And I think for us in the county court, we are the court, as Judge McDermott has said many times, the people's court. So what we see in the county court are most lawyers who are really trying to get their teeth wet. They're trying to have a bite of the apple. They're trying to learn how to practice. It's a proving about. And our court system is, as most of you know, very much of a volume court. I've seen numbers anywhere from 650,000 to 700,000 cases in any given year. If you combine the traffic tickets, if you combine the criminal charges, if you combine the preliminary hearings, you combine rent and restitution, you combine all the civil cases, we are a very active and busy court. We are going to be busier because the Supreme Court has now changed our jurisdictional amounts. You can now file a civil lawsuit in county court for up to $70,000. Small claims cases, you now can file up to $7,500. I say that to each of you because in our review in the last 6 weeks, since they had changed those statutory bases, our number of civil filings is up somewhere between 15 and 20%. And this is not a reflection on my fellow judges in the district court, but I think it's an equalization of what we're going to be seeing. We're also going to see a lot of a great influx in small claims cases because so many of the cases that would have been filed in our regular civil docket, if you had a small collection case and you were hiring a lawyer to, in fact, do that case for you, and they're going to take a percentage, whatever that percentage will be, 25% or a third. They don't have to do that now. They can file that. They can file up to 10 cases a year in small claims court and save the expense of having to pay a lawyer. That is the major things that we have seen. That's the major change we've seen in the last year with the Nebraska legislature. And I do think it will affect each and every one in this court, in this room today, because it does affect our ability to maintain and manage cases on a fairly timely basis. Our division, we have 3 basic divisions. We have the probate court, we have the civil courts, and we have the criminal courts. There are 12 of us. For civil cases, we sit in 4 separate panels. Each of those panels is in charge during months. My particular months are February, June, and October. During those months, myself and 2 other judges are required to handle all rent and restitution cases. We have civil cases. 1 month out of every year, we have jury panels where we are in panel to do Class 1 misdemeanors. Class 1 misdemeanors under Nebraska law, if you do not practice in criminal law, is a requirement of having a mandatory jury trial unless that jury trial is waived. We are very busy. We have just recently been fully staffed. We've had, within the last 2 years, 3 new judges due to retirement. What I would ask of the lawyers, and I think this is the most important thing that I see, is when you come into our courtroom, be prepared. please be prepared. We do not have the same rules and evidence that our district court colleagues do. We do not have a court reporter. We do not require electronic filing of exhibits. The exhibits become the responsibility of the lawyer that appears to have those exhibits marked in a timely fashion and to be offered at the time. And I think one of my pet peeves is this: if you are filing a motion for summary judgment and you file your exhibits electronically, well, that's a document on file. You then plan on being there for the summary judgment hearing and offering those exhibits to see if there's any objection, whether it be foundation, hearsay, or whatever. Because here's the problem: I'm not going to handle your exhibits. That's not my job. It's your job as the practitioner to make sure that if you do in fact have a summary judgment motion, that the evidence is available to you at the time that it is submitted. If you're defending someone, please look at those Nebraska discovery rules. Even lawyers today do not look at those, and they do not realize the necessity, if you're going to object to a summary judgment, that you file an affidavit and you provide those documents within 10 days prior to actually having a hearing. Most of our civil hearings occur on Thursday morning. And again, we can set civil trials in our 3 months that we are on civil. But the problem with that is very often we have so much discovery. We're seeing an influx of discovery now. And I think that's part of the reason why we have had some revisions in the Nebraska rules of discovery. Overall, I think those new rules will help. You new lawyers, make sure you look at those rules. They're an adaptation under Nebraska law that basically parrot what the federal law does. And the wonderful thing that the Supreme Court and the Court of Appeals have told us is, because we have very few interpretive cases right now as to how discovery would be ruled or how we should rule on discovery. And in the absence of any direction from the Nebraska Supreme Court or Nebraska Court of Appeals, we can look to federal cases that deal with discovery issues to give us some guidance. I have my own rules with regard to briefing. I have no problem reading briefs. I really don't. Do me a favor. Please don't use chat box. Don't use AI. I could tell you horror stories about individuals who have used both of those mechanisms. They've argued a case to me, and the case that they argued may be a case, in fact, that it has nothing to do with the principle. Remember, if you are going to sign a document, whether it's a pleading, whether it's a brief of any kind, it's your signature. You're attesting to the reader that you have, in fact, researched the document, that the cases are accurate, that they are factual, and be prepared to answer that. My own rule is this: if you want to brief something, I'm happy to give you that opportunity. I always do joint briefs. In other words, we'll praise it and defend it, have the opportunity to brief it, but I give them a deadline date. And to help you lawyers out, I do the same thing to myself. If I tell you you're going to have a brief to me by June 10th, I will put in the order that I will have an order out to you no later than June 30th. I think if I mandate writings to you, I should mandate those requirements to myself, because I think that helps me deal with case management. It helps me to deal with case flow. That's kind of my own rule. I think the most difficult case that you would see, our criminal court system, it manages itself. You know, we sit in that court system in basically 6 different courtrooms, handling preliminary hearings, traffic arraignments, criminal arraignments, criminal prosecutions for matters. Every Thursday morning, the county court deals with sentencings. I think is very important, especially in a criminal case where a pre-sentence investigation has been ordered, that if you are representing a defendant, make sure that you have access and that you see the pre-sentence investigation before you come into the courtroom. I think it's really important that you can share the recommendations of the pre-sentence officer with your client, and you are prepared to argue that case to be when it comes up, when it's called up. I think one of the most problematic areas that we deal with is the probate court. The interesting thing in Nebraska is we have probate jurisdiction. We handle cases that have millions of dollars, and they are also some of the most complicated cases. If you do not practice in that area, make sure you look at the Nebraska probate code. Make sure you know that your applications are appropriate. And if you make an allegation specifically in some type of a guardianship, whether it be temporary or whether it be permanent, make sure you have the evidence to support what your request is going to be. Probate is very difficult because I've often talked with my district court friends about, they talk about divorces and how it's so off-putting that you had a whole partner's upset with you. Come into my courtroom, I've had a couple times when I've had 125 heirs fighting each other for what's going to happen with mom's estate. It's a very difficult, time-consuming occupation. If we could do one thing, all of us would love to be able to donate and to use more to be able to handle those cases in a more expeditious manner. It's also the most problematic cases, but you know what? We have a great probate code. The Court of Appeals and the Supreme Court had interpreted a lot of the permissions. Make sure you beat that. If I was going to give all young lawyers general advice, I'll give you the advice that my long-term partner told me many years ago. And it's really twofold. I practiced law with an attorney by the name of John Respelay. I don't know how many of you would know John. When I started with him, my first job was to work with the Douglas County District Court judges as their clerk. And I did that for a year. And then I joined John Respelay and John DeMari. Well, one of the first things John DeMari looked at me and said to me, he said, "Son, he's got to learn to drink coffee." And I said, "Drink coffee? You have drink coffee, do you?" I said, "Oh, no. I want to tell you what. You've got to learn to drink coffee. If you win, if you lose, invite the other attorney to sit down and have a conversation with you." He said, "Your life will be much easier if they know you as a person. Oh, that cup of coffee versus beating them up with letters or not talking to them. They'll appreciate the fact that you are a human being, that you had the ability to visit with them. Please don't be afraid to talk." Talking is an essential element that we've lost in this profession because it's so easy to get mad at another attorney, to rip out your laptop, your cell phone, or your computer and write an email. Think about it. Because guess what? You're very likely in this community going to run into that lawyer at some point in time again. And that lawyer is going to remember that you were a jerk or how cruelly you treated them. And as John told me later on, he said, you'll settle a lot more cases in the future if that lawyer knows who you are than you ever will in a courtroom. Your life will be happier, your client's life will be happier, and I will be happier because I can assign you other cases. Kind of self-serving policy. But it's very true. Please, think about what you say. You have a reputation. A small community like this, it is your reputation that will carry you forward into the future. If you're a jerk, it's going to be much more difficult to deal with individuals than it is if you, in fact, become human. Have a cup of coffee. Have a conversation. Talk with your opponent about the case. See what you can resolve without actually appearing back in the courtroom again and having validity in the case. I could talk longer and longer, but we have far more experiences to our might, so I thank you for the attention this afternoon.
Judge, we do have a couple minutes here. If we have any questions from the audience for Judge Harmon. I see a lot of long-standing practitioners here. Anybody want to throw a question out? Yeah. This is kind of a difficult mic here, but maybe it'll work. Yeah.
Thank you. My name's Margaret Schaefer, and I'm the managing attorney at a centralized intake unit in Legal Aid in Nebraska. I'm advising people that are pro se. What advice do you have for our pro se litigants?
Pro se, I think you probably know, given what you do for a living, the number of pro se individuals that we do have in our courts is growing exponentially each and every day. And I think you deal with it as much as we do too. Pro ses present a lot of difficulties for us because they don't really understand the rules. And our Supreme Court and the Court of Appeals have both said, we can't give you any special treatment. We have to treat you as if you were a lawyer. one of the things that I would suggest if you have an individual on the other side is have that conversation with them. Because if they appear in my court and they are pro se, I'll talk to them right up front and say, listen, I can't give you any special treatment. That's not my job. You have every right to represent yourself. You have every right to do what you think is best for your case, but I can't give you any legal advice. I will rule on your motion, but you know what? You may want to have a conversation with opposing counsel outside of my presence. For those of you that are practicing, I would take advantage of that opportunity to visit with them to see if you might resolve some of those difficulties in some amicable way. Obviously, I'm there if you can't, but the more you can talk, the more you open up those channels of communication, the better off your life would be. And I realize, because the greatest difficulty that we have are with those same people who don't understand what we do or why we do it. But the communication, again, is essential.
And Judge, on that point, I kind of got it. On that point, I've talked to Judge Hanson, who has a lot of pro se litigants that are bringing in something on their phone. And she says, okay, if you want to offer that, give me the passcode, give me a charger, and give me your phone. Through the period of appeal, because you got to show me more than just the screen at that point, right?
I have a collection of phones in my office right now that I have marked as exhibits that they want you to listen to, and they come back in. In fact, I think in my retirement, I intend to open a used phone store. Because one of the things that I will tell them is, listen, I can't help it. We're in that gray area right now. We are trying to find ways to communicate with those individuals who are self-represented litigants to say, listen, you've got something on your phone. If you want it to come into evidence, you're going to have to mark it and you're going to have to delete it. Because it's just that simple. If I'm appealed to either Judge Keane or then appealed to Judge Riedmann, that's part of the record. And most people don't want to do that. We're trying to come up with some new rules to say, here's what we are going to do. If you are going to use cell phones in your trial, make sure that you have a flash drive. Make sure, and here's the other thing. If you have a flash drive as a piece of evidence, and this goes for lawyers also, we can't use that flash drive on a state computer system because you don't know what's on that flash drive. You could rule the whole system itself. We're trying to come up with different rules. In fact, that's one of the things we're working on right now to try to make that easier for the self-represented litigants and for the attorneys so that information would be available so that we could use it in any decision that we do, in fact, make. But it's in process right now.
And, we're dealing with deep fakes and AI dupes. And so making sure that electronic evidence is in fact what it was when you saw it, right? That's going to be the new frontier that we're getting into. Okay.
That's correct.
All right. Well, we will keep it moving here. Judge Riedmann, you are next year. You've been on this panel before, I believe. Yeah. So you're a regular.
Raise a charm.
If you can turn on your mic and hold a little bit closer and you'll be good to go. Thanks.
Okay. I think you're all going to hear a very recurring thing, probably from all of us. Some people will be prepared.
Advice that you'll receive from us. We get two types. Mostly we get attorneys. I will say that, at least for oral argument. Certainly we get our share of self-represented litigants at the briefing stage. And as Judge Harmon indicated, you treat that just as we treat any attorney would be if we only have to apply it. And I think our rules are complicated. Our rules changed dramatically in January of 2022, and we see the attorneys themselves are really having a hard time either remembering that we changed them or even just reasoning to figure out the itch that takes them. But typically on oral argument, we see two types of attorneys. They're the attorneys who either tried the case and now they're appealing it to us. The thought being, well, I tried the case. I know it better than anybody else. I ought to be the one that does the appeal. I have mixed feelings on that. I think there are two dramatically different skill sets that apply, one to trial attorneys and one to appellate attorneys.
in the trial attorneys are the ones who have that great jury appeal, who have to stand up and dip their hands in their pockets and just have a conversation with the jury. That's not really what appellate lawyers do, because it's much more focused on the law and the application of the law. You don't have to be fancy. You don't have to be able to create or have a conversation with a stranger in order to be a back-heavy adjustment, to be able to be articulate and organized and be able to know what the law is, how your facts apply to the law. And I'm not an advocate against trial attorneys, because trial work was one of the things I disliked the most about private practice. But it's a different skill set. I'll say this. I practiced with Gene Welch for years. One of the best trial lawyers I ever saw. But he would come in and hand me a draft of an appeal that he had started after a case and say, "Can you finish this?" And I would most likely look at it and go, and I just start, because writing wasn't distracting, but boy, could he try a case. So I think it's a little bit of a double-edged sword, because an attorney who tries a case has a recollection of what happened at trial, mostly. And I say mostly because it never failed. I typically did the appellate work in our office when I was in private practice. So I wouldn't try the case, but I would get the record after, you're as an appellant or an appellee on appeal. And if they were the appellant, the attorney would come in and he's like, the trial court, they screwed it up. We had a conversation about this. This is what happened, blah, blah, blah. And I go through the record. I don't see that penny. So I go back and say, "Are you sure you had that?" "Yes, I had that conversation. I said this, they said that." Was it on the record? Oh, Chambers. And it's not on the record. So if it's not on the record, it's not on the PI. I mean, we don't address anything that you can't substantiate in our record. So that I think is kind of the downside, couple of downsides. If you're a trial attorney, then also be hard. If you're just getting the case on appeal, you're starting all over. So you don't have that historical knowledge. That's a pro and a con, because you get what we get. You see what we will see, and you have to make your arguments spoken or brief and on an oral argument based upon what is before you. So it's a little more replicative of what we actually do. So just something to keep in mind if you're the trial attorney. You are a great writer and you happen to have both those skill sets. Starting with the very basics, filing an appeal. It's 30 days. The notice of appeal has to have in 30 days. And something that messes attorneys or people who want to file a notice of appeal up the most are the months that have 31 days. Because if your month has 31 days and the order was filed on the 5th, your notice of appeal is going to be late. You file it on the 5th and it's 101 days. And we have no ability to set that date. Unless, of course, it happens on a weekend or a date or not. It's a holiday or a court are open. But it's a business day. There's no way for us to extend it. So I had made reference to the fact that our rules changed in January coming home too. I think one of the rules that has created the biggest hardship or biggest problem is the rule that requires the bill of exception recipe to be filed at the same time as the notice of appeal. The rule says the notice of appeal, recipe, or the bill of exceptions and the transcript must be filed at the same time. And for the bill of exceptions, if that doesn't happen, you don't get to file a recipe late unless you ask the court for permission to do so upon a showing of good cause, which is defined as something outside of the party's control. So if you file your notice of appeal on day 1 and on day 3 you realize, and you want to file a notice of appeal and your response to us is, well, can I file this late because I didn't realize the bills have changed? And for miscellaneous motions, Judge, is probably in so low. That's probably not the cost. And without a bill of exception, you can have the testimony and you have the exhibits. So most likely, you're not on the successful court. The rule on the recipe for the transcript, although it says it too must be filed at the same time, is much more forgiving. The rule allows for the supplementation of the transcript and does require the court to do so. So I would just caution you, if you're going to file an OZ, well, I'm sure you have that recipe for your own sessions database. In conjunction with that, once you file that precedent for a bill of exceptions, the court recorder is within 7 days going to tell you how much that bill of exceptions is estimated to cost. Is estimated to cost. If you don't pay that estimated cost within another 7 days, the court reporter will not tell you bill of exceptions. And then ask for E to pay for the island high time again also the cost. So those are the initial rules I think that are the trickiest for legal verifying and appeal. The notice of appeal, and I'm not really sure why this is, but if you're representing a parent whose parental rights have been terminated, the rules require that notice of appeal be signed by the parent, not the attorney. We often, in accurate situations that I'm aware of, we will do a show cause order and give you 15 days to provide an affidavit from the parent saying, oh yes, I intend to proceed this appeal. I don't know why it's that way for an appeal on the termination rights, but it's not like very hard to mean it. But those are what the rules say. 30 days. 30 days from what? The notice of appeal has to be filed 30 days from the filing of a final order or a judgment. So we have statutes that define what's a final order. Sometimes, especially in those complicated probate cases that Judge Harmon spoke of, that's not such an easy determination of what's a final order. And within the last year, what's a final judgment, I think, has become a little more complicated as well. There are 2 cases from the Supreme Court, one that came out last month, Albert versus Keating O'Hare, and then one that came out in June of 2024, DM Roofing and Site versus Distribution. In those 2 cases, the Supreme Court talked about a judgment, and then judgment, the rendition of a judgment being a filing of an order. The exact language is taken from Nebraska Revised Statute 25-1301 that says that the rendition of a judgment is a single written document stating all the relief granted or denied in an action. So does that mean if you have a 2-party action, well, you have a 3-party action, a plaintiff and 2 defendants, and one defendant gets dismissed, and then later on, the plaintiff gets a judgment against the other defendant, that order has to make reference to the prior dismissal? Because if you look at the actual language, it would seem so. So I'm actually very curious what the trial judges are going to do with that, because so very often you have either multiple parties or multiple claims, some that get dismissed on separate judgments, some that get dismissed on a motion to dismiss, and other ones that maybe go to trial. Very rarely do we get one order that says, on October 12th, I granted a 2-vote in favor of this one, and on this date I did this, and on this, and now finally this is the last thing before he cares what I do. We just somehow hit those kinds of orders. But I'll be curious to see what the trial court does with those 2 cases. Briefing. One of the things that did not change in our rules is that you have to assign and argue everything that you think to the trial court did incorrect. If you're if your brief does not contain a separate section of assigned errors, and that really means a section that says assignments of error 1, 2, 3, 4. If it doesn't contain that, and then contain a corresponding argument, most likely you will get an opinion that says this error was assigned but not argued, or this was argued and not assigned. In either circumstance, before will likely say the oral address it. I think the easiest way to make sure you comply with that rule is if you have 4 assignments on error, you have 4 argument headings that are exact in those assignment errors. Don't skip the section that says assignment of error and list them out 1, 2, 3, 4. Because if instead what you do is use it as a heading and then do your argument and then another heading, your argument, you don't have a separate section. So that is the one fatal thing when it comes to briefing, because it just will be on the task goods. It's not possible to hear it. In criminal cases, starting making was in 2019, State versus Wurzel. You have an ineffective assistance of counsel claim. You cannot just assign counsel was been affected in your assignment error section. It must state why. Counsel was ineffective in failing to review the pre-sentence investigation report. Trial counsel was ineffective in failing to file a motion to suppress. Right there in the assignment error section. Like, if you go back and you look at State University and you look at all of the times that he has said since 2019 is a base, how many appellates still missed that part and instead just assign house was in fact. Again, just at the assignments of error in other ways fail to do. I notice Judge Harmon says he doesn't mind writing. He doesn't mind reading briefs. We read a lot. That's our primary job. We read the briefs, we read the bills of concessions, transcripts. So being really concise in what you want us to address is super helpful. And I'll also say, I'll just be selfish, but to give you the key, if you want us to look and go, oh, this is so much easier, oh, you could have been. I think putting in our brief, when it's helpful, an exhibit. It is diagram, it's a picture, it is something that's complicated, and it particularly thinking, water law cases, when you're saying, you have this street and this is to the east and this is to the north of this runs through. And I'm sketching it all out of my little CAD trying to make heads or tails of it. If you, the counsel that puts a picture of it in there, or the diagram that was offered and admitted it to evidence, so helpful. I think one of the great things during COVID was when our oral arguments were via Zoom, and attorneys would say, would you mind if I share my stream queue? And they would pull things out. Geez, so much ease, especially if the record says things like, if I'm reading the record and it says, well, over here you'll see, and then down there, witness, can you tell over where, down where, I don't know what you're talking about. So when counsel would put that up and talk about over here and down there, that makes so much more sense. Super helpful to find it on some of that and stuff. Cross appeals, they still seem to be a sticky spot for people. We can only have one appellant. So if somebody files a notice of appeal, they are the appellant. If you're the other party and you want to bring something to our attention and have it corrected, you have to cross appeal. It's not a separate document. You don't have to file a notice of cross appeal. But what you do have to do is follow the specific rule on cross appeals. Says on the cover of your brief, it has to indicate it's the brief of the appellee and brief on cross. Do your appellant brief have a separate section of the brief that says brief on cross appeal, and it's referred exactly the same way as brief ad hoc. Lots of times you'll see cases where it says, Mr. Smith attempted to file a cross appeal but did not follow our rules that will go on address it. So, knowing those rules are super helpful, especially you really like unjust. Okay, despite having said maybe a lot, I think one thing appellants neglect to do most often is file a placard. You should, if you are the appellant, you get the last word. So often you don't get free hikes. And what always baffles me is when the other side files a brief on cross appeal and there's no goal. Because then we have no idea what the appellant's response would be to those arguments that are made by the applicant cross ballot. So take advantage of that ability to file a reply brief. If you've noticed, we don't hear a lot of arguments anymore. We used to hear a lot more arguments than we used to. We dispose of a lot of cases on the briefs themselves. So if you've got that really one great argument, then save it for telling us in person, because you might not get that chance. If you have a case that is on the call for oral argument, know that there's something in your case that has piqued our interest, something we want some clarification on, something we want the attorneys to discuss beyond what they not quote in their briefs. But there's a reason. We no longer hear oral arguments just to fill a box. We hear arguments on cases for a couple. And a lot of that has come from recognizing how expensive it is to you first white. And if we don't need to add the additional incidents of someone preparing for an oral argument and maybe try to for response blocked, is that argument, if the client doesn't have to spend that money to resolve the case, normally see anything that to happen. Now, if you'll get a letter that says your case has been submitted on the briefs or so that to go live. If there's a new case that's come out or something that you say, oh, no, I really want oral argument, not just to rehash what's in my brief, but because there's something important I need to tell you, the rules provide for you to file a motion and say, oh, but please reconsider now because a new case has come out at a top to discuss or whatever. But take advantage of that. If you get a Rule 11 letter and you think there's either that or no left something. I will say my pet peeve, since Judge Harmon did a pet, I'll give you under your pet peeve, and it happens on oral argument. And it's when an attorney says either, well, I wasn't the attorney who tried this case, so I don't know what the record says about that. Or the attorney who says, well, it's been a while since I read bill possessions. And I'm always thinking, what did you do? Why did you not make a bill of exceptions before you come make a cookie for us? So I love talking to new attorneys who are petrified to give their first oral argument, because what I say to them always is, you will most likely be more prepared than, because they give me the whole, but they've been doing it forever, they're so seasoned. And sometimes doing it forever and being seasoned makes people lax. And if you're a new attorney and you're going into your first oral argument, chances are you are the rules prepared for sneak up. So don't take it for granted. Just general observations. Be aware of our standard of review. The results you get in an opinion from us might not be the result you would have gotten from any one of us as an individual shareholder. But we are constrained by what our standard of review is. And all the time that standard of review is abuse of discretion. If you read the Supreme Court pieces, they think that abuse of discretion standard has kind of come to more or less level, where I believe the commenting of concurrence was, the door is ajar, ever so silent. So, and if you use a discretion standard, if you're seeking reversal on that basis, it's really hard.
And then, I guess the final thing, once you get our opinion and you don't mind it, you can file a motion for rehearing.
And if we've truly made an error, I'd really rather you do a motion for rehearing, let us fix that on rehearing, than that petition for further review that goes to the Supreme Court and they get to write an opinion and tell us where you've been routes. Ow. But give us a reason. What did we do wrong? Not just a rehashing. No, you didn't really consider my argument on a side reform that Judicial for. I'm not one because of all the reasons I stated in my original brief. It's probably not going to be affected. But if there's truly something of, well, I raised this and you didn't even address this issue. Or you stated the record as having said X, but the record really says Y. I would like up 2 meetings and then bread. So don't forget about the motions for rehearing. They don't attend these to you.
How's volume these days? I mean, a breakdown. How's the volume of cases that you're getting?
The volume is down post-COVID. We used to dispose of, I'll say, about 1,200 cases a year pre-poll. I think last year we were right about minor. So they've gone down. I don't know if it's a reflection of the trial courts. I think they're so very busy. So why people are kind of healing, I'm not all that certain. We do still get a lot of self-represented litigants. And AI is tricky on that end for us because honestly, some of the briefs have gone much better. The cases that were cited don't always stand for the proposition for which they're cited for, but they're cited. I mean, they now have cases in now. The trick comes for them is when we have oral arguments, and sometimes we will have self-represented litigants do oral argument. And that's a little trickier when some other entity has break your brief for you, and now you can ask questions about this.
Fascinating. I'm sure there's some that we can find online, video of that or of those self-represented litigants.
Anybody other than us.
Any questions from the audience? Yeah.
Several years ago,
Oh, you got to go really close.
many years ago, I filed a brief. I don't remember if it was the Court of Appeals or the Supreme Court. I sure it was this. Okay. And it got sent back to me because I had not used the proper font. And I was given an opportunity to repair that because I still had X number of days before my brief was due, and I didn't have to ask for an extension. Well, is that something that's also possible for someone who submitted a brief and failed to have a separate list of the statement of errors?
So your question was two kinds of tricky things. So one, replacement briefs. When a brief comes into the clerk's office, they have a checklist. Are the margins correct? Is the type correct? Are all of the sections there except for the assignment errors? That's a substantive issue. And if you file a brief that doesn't contain an assignment of error, but you have some other errors in it, you may get a letter that says, your brief is not compliant in the following manners. You will not list the assignment of errors. You have X number of days to submit a replacement brief.
But not on anything so soon that would be.
That rule has recently been changed. And we used to do a ton of replacement briefs for eager fakes in my email address of the attorney, not on the cover page. Replacement. I mean, it's a full replacement brief. So that's been changed in recent years of, okay, petty, but yes, we would really like everyone to just follow the rules that are set forth. But for those petty things like that, we're not going to order because it delays the whole process. Because the appellee's brief isn't going to be due until 30 days after your brief is in. So if we're ordering a replacement brief, we're just pushing everything back. So the rule has been changed recently, and I think it says something to be effective. The court may order a replacement, at which time the original brief is stricken in kind file replacement 3, changing only those items which have been identified by the bench. Because we would get situations like that where something is missing, including the statement of errors, and a replacement brief would then miraculously have this as evidence of error. And the appellees were going, wait a minute, that's not fair. So, but it does seem harsh. It does seem harsh. On the assignment, if you don't have an assignment error or if you can't correct it, I agree. I didn't write this.
I had 2 cases that have been set for oral argument that I've later received notice that they've been removed from the oral argument schedule. Is there a reason that that has happened? I asked because my client was questioning me about it, and so I didn't have a very good. I didn't have a very good response to them. But is there a reason that that happens? Are there other cases that are assigned, or had you just determined that?
Well, did you get continued or did you just get removed? And it got disposed of by roll up? Correct, right? So if you look on the Supreme Court website, it will list all of the cases that are on the proposed call. Okay, those cases are cases that have been assigned to us to decide. As we work our way through those cases, sometimes on all of the cases actually that we are assigned, we make a decision. Does this case need oral argument? Or do we think we can dispose of this by rule array? And if we think it can be disposed of without oral argument, we will ask the other members of our panel, here's the issues in this case. Here's what that base law is. I don't think it's going to need oral law. And if we get the votes of both people, then it will be disposed of without oral argument. So your case may very well be it was either just a close call, or it's one of those cases where we really haven't gotten a good handled that on whether we should have oral argument on that case. So we're going to leave it for oral argument. And then as we get closer to it and we work our way through the cases, we get to your case and realize we probably don't need oral argument on that case.
Any other questions?
Baby Josh?
We're going to move along to, I'm very excited. We haven't had Iowa as part of our bench bar until this year. And so I'm going to turn over to Senior Judge Eveloff from Iowa to give us a little bit of background and then tell us what we need to be knowing about your courts.
Thank you, Dave. As Dave said, I've been on the bench for almost 30 years over in the 4th Judicial District in Iowa. Our district includes 9 counties in Iowa. There's 8 districts in the state of Iowa. When I got Dave's general outline for each speaker, I thought I'd mention a few things that are changing now in our district, in Council Bluffs and the other 8 counties. First thing I want to let everybody be aware of is if any of you do any civil work over in our district, our rules call for summary judgment motions to be on file no later than 60 days prior to not less than 60 days prior to the date of the trial. We've been running into trouble with scheduling those hearings, and unfortunately they get heard maybe a few weeks before trial, which doesn't give the judge much time to research, decide the case, and prepare an order. The new scheduling orders starting about a month ago are now going to be telling you that they have to be on file no less than 90 days before the trial date's set. When I got on my work computer this morning, we had an email from our district court administrator telling us that we need more child and family reporters. For those of you who practice family law, what that is, we used to call them guardian ad litem for many years in divorce. It's
the parties could request one, need payment as agreed to between the parties, and that's been changed now, maybe five years or so ago, to become child and family reporters. We currently have 9 attorneys in our district. I noticed when she set the list that those that are doing this at this time out, there are 2 of those 9 that are taking a pause from being appointed as a child and family recorder. So if any of you listening now, or Dave told me earlier, this is going to be viewed by several other attorneys later on. If any of you that do family law cases across the river in Iowa, you would sure be eligible to put your name in to be considered as a child and family recorder. A few months ago, I met a judge from the Sioux City area. He had come down to our courthouse to hear a divorce that involved one of the attorneys in our area. So everybody in the 4th District recused themselves, and he came down, and he was there for the final hearing on it. In our district, all temporary hearings in family law matters are done by affidavit only. The attorneys can call in on the phone, argue their points that are set out in the affidavits, but there's no testimony given. This judge out of Sioux City told me he loved that idea. Well, he had his case with our local attorney, and he took it back to the judges in Sioux City. I was told no. So they will still spend 1 to 3 hours on hearing evidence in a temporary matter in a family law case. And I know from talking to different attorneys around, I know there are some in the Omaha area that will also go up to the 3rd District, but starts as close as Ottawa, which is about an hour drive from Council Bluffs. So that may affect some of you. Just make sure you know what the local rules are. We go to a different district, the Iowa. One last thing before I move on. Recently, I received an email from our chief judge. Our state Supreme Court started a mentor program for judges. In Iowa, all judges have to record every month if they have any cases that are under review for more than 60 days. Yeah, so we have to file them regardless. But if you have any, you have to send them out, have to give your reasons. And what this new program talk about, there's going to be a mentoring program, one judge in one district, hiring a mentoring judge and a different issue. Not deciding a case quorum, but evidently there are 3 or 4 judges on the eastern side of our state. There's just way behind to get their orders out. And our Supreme Court thought it's a talk to a judge from another district, maybe he has some ideas, and then not telling them how to decide their case, not even getting into the facts with it, just trying to get tips on how to decide your case, but what to think about. Because what I found, I started to associate judge, and when I started juvenile cases, misdemeanor cases, and small claims. And the small things, I didn't have a court reporter. I found out I had to take something under advisement. I better get that order done within 7 days, because my scribbled notes, they were ineligible in me oftentimes, and trying to remember everything that happened, my memory just wasn't very scary, but it went too long. So our district does not have that problem. Hopefully you do practice over in our district getting rulings out in a normal amount of time. I retired full-time the end of 20. I've been a senior judge since that time. What that means was I have to work 65 days a year. What I've been assigned, on Wednesday mornings, I do child support cases for the state. And on Wednesday afternoon, I have to see over our mental health court program for a district. So when Dave was telling me, do's and don'ts, technology, I said, it's been a while since I really tried a case. They've given me a few divorces. I tried a little injunction case recently, involving our Hog Wild restaurant at Council Bluffs, but nothing backbreaking like I used to hear when I was full-time, or what my colleagues are full-time are hearing now. So what I talked to Dave about today said, I'm sure you got a lot of good stories regarding do's and don'ts, so he's maybe a little baited, but a few things that I thought of. First thing, because I was coming over here to the Omaha bar, it's involved an Omaha criminal defense attorney who came to Council Bluffs quite often. I'd see him quite often. This was in one of the other counties in our district, one of the rural counties in our district. I'm hearing a criminal phase indecent contact with the child to a jury. And pretty much all of our county attorneys at the time, they were all told, get us jury instructions so far. Yeah. This particular county attorney focused more on his private practice. He told the defense attorney in Omaha, don't worry about the jury instructions, we'll be done. So I'm down there with on the other side. I'm prepared to propose jury instructions. I'm getting them done. They're not that difficult, but what I learned then, it's a great service for client knows the elements that the state has to prove to get a conviction on a criminal case. The decent contact with child in the state of Iowa. A child's defined as one under the age of 14 years old. So I'm hearing the state's case, and the alleged victim is testifying, and he asks her, how old are you? And she says 14. So in my mind, I'm thinking, well, she must have been under 14 when that's her. State's attorney doesn't ask her, but defense attorney on cross-examination asks her that question. She was 14 at the time. So I'm checking, and it's still 14. It hadn't changed. So as the state rests, I look at this defense attorney. Is there any motion on your client's behalf? Hey, look, that never works, but here go, like most favorable, all that. And I called the attorney. The jury had, we were back in the jury room, and but his client was there, so I had the attorney's approach. And that's when I told you, the attorney, Billy, who looked at it at closely, even the county attorney didn't know that. And I dismissed the case at that time. And I had you go in, I did, but I was like talking to you afterwards. And I explained it. I thanked him for coming in. I explained to him what had happened. And it's dismissed and been treated. So that was the case. I don't know how much after that cost his client. Come down here, valid days that sure didn't need to take up the court time. In the same regard, this involved an Iowa attorney. Know your jurors. And this happened in Page County, which county seat is Corinda. For years, I've been down there. It's another criminal trial, and it's a 2-day trial. This happens Corinda's not small in the city. This happened in a city with a town of Shambaugh, which is a very small city. Sister shoots her brother. He survives. There's Q, different charges filed, and about all the deputies involved in Page County Sheriff's Office is involved somehow in investigating, and they all testify. I think in day 2, we're taking a recess before the jury gets a case. And when I went back in chambers, Judge Davidson, who lives in Florida, his office is there, and he was there. And I walked back in the chambers, and told me, I is Sergeant so-and-so's wife on this jury. And I said, I don't know Florinda. I don't know who these people are. So told us that nobody asked if anybody knew any of the post witnesses. Just a simple question like that. And the defense attorney, he was from an adjoining county. He didn't live right in that county, but he was close enough. State's attorney, they didn't mind their deputies' wives. And they didn't get a conviction. They got it on a lesser thing. And I don't know if that defense attorney already that licked it. the relationship that you're there. Make sure if you go and try, and this is a criminal case, but in any kind of case, make sure you know enough about the jurors. Make a reasonable decision on each side, who you want is right, or in that case, probably could have excused her because, and you would have had the visa strike, but they never got to my attention. Another thing I wanted to mention, control your clients, and I kind of slashed out with length of here. And what I was thinking of when I said this 8 or 9 years ago now, I'm burying a property here between two neighbors on the old Lincoln Highway out near Crescent, Iowa. And it's two made. It's a bench trial. And when they had their trial scheduled in conference, it's going to be a 2-day trial. 2 days. So they give them 2 days. We get to 2 days. Not going to be done in 2 days. Day 3 is about a month away. And get that day 3. Day 4 is not another month straight. And then day 5 is another month away. So we're out 3 or 4 months after we start this trial before it's all submitted. I told you earlier about small things case. If I didn't decide within 7 days, I start forgetting things. This is a bench trial. It's started, 3 months earlier. Thankfully, I have a court reporter that can, go through a record with. Why I had control your clients with this one, though. One of the attorneys let his client run the parish show. I saw more videos, more pictures, more ridiculous questions. And I had 5 pictures, I'm going to call it dog poop. It was on his client's porch that had to come from the neighbor. The size of it, the size of the neighbor's dog. I didn't care. It had nothing to do with whose viewed your hat. But this attorney just couldn't tell his client, no, it's not necessary. We don't need this. So we went from a 2-day trial to a 5-day trial. And I had another one. Cole's department girl was appealing a property assessment. And Coles hires a large firm out in Minnesota. 2 of their attorneys come down to defend them, or represent them. And our county hires a private attorney. And this is set for a 4-day trial. We start on Tuesday, which usually is going to go through Friday. And they come into my office. What I said earlier about talking to each other, getting lawn purpose, I think Don brought that up. So they had talked, they'd come in to see me, and the private attorney, who I do very well for the county, told me with the tire was narrow, some issues. We don't think it's going to take a full 4 days. Then we get into trial, and he takes forever. I'm not going to limit on the first Minnesota, it's our local attorney. We not only didn't get it done Friday, the attorneys from Minneapolis had a flight late Friday afternoon, so they had to leave. They came back down the following Thursday. We got it done in day 5. So don't tell a judge it's going to be shorter then go longer. That didn't play well. Civility is how I wrote this down. What I was going to talk about on that, I had a normal attorney who I'd had a few times before in family law cases, very polite, very respectful. About 2013, I think it was, we went electronic. And that's when we started having more temporary hearings by telephone at the time. And he got on the phone with the attorney on the other side, and I'm on there. And he was a different person. When you sit in my office, face-to-face, right next to the other attorney, very fine, very polite, he just started going on. I never saw or heard that side of them, but it's so easy to do that. And when you're not near each other, when you're away from each other. As Tom said, you've probably worked with these other attorneys later on. be cordial. It doesn't cost any more. As long as you might get an issue or two resolved. You might not get it all resolved, but you get a few things resolved, shorten time for trial, save your fines and money. But I don't think it happened. I did talk to a couple of our judges, as well as a chief judge, about anything they'd like to talk about. Or one judge even told me he's had a couple of cases in the last year or so with attorneys over here in Nebraska that in their briefs, whether it be a summary judgment brief or whatever it was, would cite Nebraska rules. That's all fine and good, but then I only don't follow those. So make sure, and I know a lot of things are, done over and over again, but make sure if you open our jurisdiction, don't cite a Nebraska rule. One of them even told me in one case he had, and I think that was our chief judge, told me he can even see sarcasm in pleadings, that they're just really putting dents at the other side, the other attorney. So, yeah, if you don't get any culture that, don't do that. They all talked to me, to the judges, and I had it written down anyway. Repetitive gives you point. If it's tried to me or tried to any judge, we don't need to say 3 times. And I know one family law attorney, and that's in danger courts, a counsel plus, who just loves to get it in an hour's worth of testimony. I'm sure say it's thing 3 or 4 different times if she thinks it's important. She'll get it any way around it. As I said, it's been a while since I've had any trials or a lot of technology. The only thing I came up with in that regards back when Ottawa County Attorney's Office using PowerPoint presentation, I was hearing an OWI third offense to a jury, and another judge had a motion to suppress hearing of this matter. I don't even remember now what ruling was, but there was something couldn't be discussed from the jury. And the attorney for the state had a new assistant in there with her, so he could get some experience. And he was helping her run the PowerPoint presentation. Well, one of her presentations involved the issue that was not supposed to be seen by the jury. She got it off the dirty. He thinking that, well, she didn't even do that. He put it back there. Then it's had to like forever, but it was up there 5-10 seconds. Defense attorney was from Des Moines, Bergen, and tried in one day. This is about 4:30 while they're in closing arguments. And they're on a urge. I just hate to do this, but I have to ask for a mistrial. I told him I hate to do it too, but I give it to you. So, be very careful what you put up there. And one last thing I was going to discuss before we get to that, when the attorney from Legal Aid mentioned pro se litigus, on Wednesday morning, like you heard, the child support cases are brought by the state, and more often than not, the individuals are pro se. I always give the state's attorneys time to talk about these matters to the clients, see if they can resolve them before we had a formal hearing on it. And oftentimes I'll go in there, especially when their folks say, well, what I love about being the chief judge, the child support, you're only regarding child support. I don't have to worry about visitation, custody, any of that other stuff, and tax exemptions. I love that part. And so often these people want to bring those up, and I could just tell them that. And I have had a couple that have got there. One in particular stands out, and it was the mom's new boyfriend. He didn't think I was, okay, enough child support for her. Yeah. He didn't care at all for my decision, let's say. Yeah. But, you do much, you just try to work on this, and, we got to treat them singles. This is anybody else, but we try to explain to them why they get away. and now we have so many pro se forms, it's custody is an issue or something like that, I can direct them right down the hall to our clerk's office. It can direct them to the pro se forms, and they can file it on their own. Last thing I want the lady to, and this just happened to me Wednesday afternoon. It was just so appropriate. We were interviewing a 41-year-old lady for possible admission to the non-golf court program. We had a lot of concerns about her. She had her extensive history, and our probation officer in particular has a concerns because she never really successfully completed probation. And so we had her over and we're questioning her. She said, I'm 41 years old. I'm a grandmother now. I want to change my ways. She had just gotten out of York, was over in our jail with 2 zoning theft charges. And all of a sudden, I don't know what she kind of figured out off it. Told me the prison in Iowa is much easier than in Nebraska. And I know when I send somebody, the state always lets us know when somebody's getting out of jail or prison. And sometimes I'm really amazed how little time some of these people do, especially on property crimes. Now, this lady, I think, would do more in the state of Iowa because her pretrial release evaluation, the officer that prepared that, said she stopped listing after 10 convictions, but she had 14 total arrests in Iowa. So she went around, she was somebody I could glean what she'd know, which was easier to serve time or now back or so. That is everything I had prepared.
Hey, Dave. Good afternoon, everybody. As you said, I'm Mike Surveyor of the District Court in the 2nd District. Cortez Martinez, Foxted. Thompson, our full-time District Court judge, is in Papillion, and I split my time between Cass County and Sarpy County. I'm going to start off with a little bit of an apology. Anyone that's had a case in front of me the last, say, 2 or 2.5 years may have noticed that it's taken a lot longer you might expect for you to get any kind of decision out of me. It just more delays than you might normally expect it to have. By way of explanation, Cass County, especially but Sarpy County too, I've seen a large increase in filings in the last, say, 3 years. And my perception, at least of Cass County, is that a lot more of them are being tried, a lot fewer are being settled. That just backs some things up. I'm trying to change the way I do a few things, the way I calendar and some other things. I think I'm catching down. But again, I apologize for the delays you might have experienced. You got stuff in front of me. First comment I would have is regarding if you're, and we get this a lot, there's quite a few of you that practice, regulate Sarpy County, kind of adult roles, and some that go that aren't there that often. Our bailiffs and court reporters are, for the most part, pretty friendly and helpful people. I think they're free. Feel free to call in and just say, "Yeah, want to do this? Tell me the best way to go about it." And I think they'll give you any advice they can. So don't hesitate to do that. Even if the question is, let's say you just this or. But also encourage you to look at our local rules. We're hoping to renovate those some, but they do have some particular things that are particular to Sarpy County. And I would encourage you to look through them a little thoroughly. One of the things we want to change is the way to organize. If you're looking for a procedure for temporary hearings, you're going to find it under a section that says the case assignments, which doesn't make sense to me, but that's kind of where it landed the first time they did that. So we're going to try and reorganize that and make it a little bit easier here. Temporary duress. I know there was a work group among district court judges, I want to say 2017 or 18, where they tried to make a more uniform rule of the way those are handled for judges. And they brought their findings to a meeting of district court judges. And the only real consensus out of that was, I think every judge agreed that changing that, make it uniform is fine, as long as you want to do it the way I'm doing it. It really was sort of a raucous for that group discussion, but we really didn't get anywhere. So that's why you're probably seeing a whole variety of things. Temporary hearings are different everywhere. And I know in Sarpy County, it's the same thing. I mark and receive exhibits. I do that because that was the practice of the judges that had that before me, and that's what they were used to. And at that time, cast another account. I don't believe Ms. Thompson receives exhibits. I don't think actually he doesn't on the record either. And the rest of us do in an open court. So again, that's one of those things. If you call the bailiff, you can help figure out what you need to do. The other rule regarding that is that you're supposed to have your affidavit served in the side before you business hour before the hearing. I can tell you, since at least at Cass County, my domestic cases are in Monday mornings. I frequently waive that rule. Part as I understand that that Friday afternoon before the Monday hearing, maybe when you realize that you didn't do something where your client finally brings you, yeah, but that, hey there. And the other part of that is that if I'm sitting there with this affidavit, everybody's in their room, rather than continue the hearing a week just because it wasn't served in time, I'll kind of make my own decision as to whether or not I think it's prejudicial or helpful to one side, and I prefer you give you a chance to file a bill affidavit when we continue the hearing. Not that I'm encouraging you to do that, but that's sort of a practical application I make to that particular rule. There is a limit in our rules on the page numbers and the number of affidavits as to whether 5 affidavits or whether 25 pages. And that excludes income information like pay stubs and income tax returns that we use to calculate child support. You need to adhere to that. And I think every judge handles those little differently. My bailiff will print out those exhibits. You mail them in. Just don't need to bring hard copies. And the reason before that is that we have 5 or 10 little hearings that morning. It becomes a big chore to get that done. It's just prefer just bringing to us with that put that on her to take care of that. I had to close the judges in our district will allow further temporary hearing. We had the first one, and then at a later point in time, after the dust settles, if you have federal information, or things just change. If it's a year trial, the children bond, a lot of things could change, and maybe it needs to be addressed again. And so I was thinking it was fine. They could bring it in for another one, so I'm just got something court to talk about. I just didn't understand it. Is the same old thing. I think we're all down there being on the use of the zoo, almost all non-evidentiary attorneys. And did you ask people that that would be allowed? I know I do that regularly also. Just a reminder, though, that we consider wherever you're at to be an extension of the courtroom. The same etiquette, the same grass applies. You do some of those attorneys are in cars or walking out a hallway. That happens. But we prefer you get to a spot and to be at the spot where it's appropriate to have that hearing. I know that's hard to do sometimes, but we more call motion days because you can be there with that sort of hour return to come up. But that would be our preference. I don't think I heard any bad stories about that app. Says you've been using Zoom for several years now. People kind of got used to it and understand that. But the same rule applies on documents on Zoom hearings too. You have somebody to get to us early. Figure out how to do that. If you print it at the court, or if you mail them in, or somehow you did the letter. Couple things we see from time to time. Attorneys tend sometimes to file exhibits in support of the motion, and I just encourage you to read. There's several cases out there in the last few years which specifically talk about how evidence to be reviewed by a court of appeals has to be in bill of exceptions. It can be in the transcript, and so if you just leave it in the file, you file that in as a board, it's part of your transcripts. It's not part of bill of exceptions. And so if you wanted to argue, hey, the judge did something wrong because of the evidence he was presented, that evidence isn't there at that record. It's got to be a bill of exceptions. You've got to mark that exhibit and get it in. And again, Judge Harmon said, not our job to do that. I try to encourage attorneys, hey, do you really want to mark a copy of that first? But that doesn't always happen. So we want to make sure you take care of that. The exhibits, they'll have exhibits for some reason. They are numbered by page numbers up you could acquire. And the actions are made of personal information. My general practice has been that it's not a reoccurring thing is, hey, do you want to sit up to this exhibit for one that complies? But we don't always have time for that. And if it's a lot, multiple exhibits at hundreds of pages, you may not have time for that. So we'd make sure we figure that out. Summary judgment, the correct rule I advised a couple of years ago, anticipates scheduling order by the district judges. So a summary judgment was filed, was have some timelines for mandatory host exhibits in, or index of evidence, briefs. Don't always see the motions when they come in. You just don't. There's nothing that alerts us that works for summary judgment is filed. It's something we can't stumble across because we're looking for something else usual. I would encourage you whenever you file that motion and to call and see about getting hearing date, but also then to let us know this is coming, so we can get scheduling order on file, so that can progress. We frequently had to extend out those hearing dates, so because we didn't know until almost the time of the hearing that A was a motion on file, and there was a scheduling order, and don't know what any of these things are supposed to do. The new discovery rules will start place January 1st. There's a piece in there about the exposure of experts. Now, there was a case this morning out of the Nebraska Supreme Court in which there's summary judgment, but because an expert wasn't properly disclosed, is the judge wasn't disclosed in accordance with the judge's progression order. The judge excluded it, so it wasn't counted part of the summary judgment, and killed that basis. The court said no, judge can enforce the progression order. The new rule says that you have to disclose your experts within 180 days of filing the last pleading called the answer. To me, that's kind of a short timeline. And the way around that is in that progression order. So after you get an answer filed, but try and get some sort of progression order so you've got some timelines, and those can only be extended to further orders. Used to move disclose your equities. I have had several cases in the last few years where I have done that, where you didn't disclose, or you disclosed the deity, not the record court. It was a pre-physician and not another expert. And so I've excluded though, and I've infected cases, I think, each time. So make sure you pay attention to those disclosure requirements and really try and get scheduled where our file can. Technology. One of my big advice on that is try it out. You saw so many times where people thought they know what they're doing and it just didn't work out well. We had the big renovation project across all the courts the last few years ago, and they mostly were more or less uniform as to their systems in place. There's still instances where I had one was a jury trial, and they were going to utilize documents and images that they have stored on the cloud, and courthouse Wi-Fi didn't support that. So they couldn't get them to download on that. We were waiting with a jury in the box. Had another one where they had it on some sort of old external disk drive, and it was great during the trial, but then they also, that I really agreed in plays the jury, they asked these clips, and couldn't get it to run. Security, the courthouse computer wouldn't download the driver to run that, and they had other issues with their chats. That's okay. Yeah, there's an hour and a half of getting that to load just in jury rewatch the videos everybody really should watch. And another instance where we had the clips, but they didn't play the whole book. So it was, for example, a minute 20, but they wanted to play 45 seconds. And that was all it was in. So if it be in the spot that the jury wanted to play that is, okay, everybody come to the boardroom. Well, they're going to play that piece of the clip. No, by the way, you can't talk while you're in there because you can't deliberate fire. So we're in the courtroom with the court recorder, and I'm playing the clip. And they're like, starting to talk about, hey, see that? No, can't talk. Don't do that. I'm not going to do that again. You mentioned USB drives. That's news to me. We're encouraging USB drives on a format that could run on the smart TVs. We have those in the jury rooms so they can just plug and play if it's up appropriate format. I don't have access to a DVD or a CD player either, and that. So other else it though. And we had a couple instances where they had audiovisual things that, for whatever reason, wouldn't play anything but their laptop. They used some sort of format or driver to it. So that's something that needs to be resolved before you use it. Because work for you doesn't mean it's work for us or work for the court appeals that they get it to make sure that that's taken care of. The next thing I guess I want to talk about a little bit, it was mentioned about claim control of the total time you take to try a case. Sometimes this is personal preference. I find it tend to be minimalist that way. But the extreme example I think I'm going to give is on protection orders. This has happened, I don't know, a dozen times, where pro se filing, for best abuse protection order. And reading through it, I don't see the elements there, but I'm required to then have another hearing. So I bring him in and tell the pro se litigant after I swear him or her in. Okay, you serious assault or serious threat of assault or otherwise sexual contact. I didn't read that in your affidavit. So tell me your side of the story. But those things exist. You need to make sure you tell me about those. And 15 or 20 minutes later, I may have stopped and reminded him about that several times. I know that he or she was cheated on, that he or she says things about the social media or to their friends and everything else, and nothing about those. Even though it might happen. He didn't hit him. Oh, yeah, should be it. Why do you say that in the last 20 minutes? That's an extreme example. But you see attorney doing that all the time. Don't vary the lead. Tell me up front. Keep it short, concise. I don't know, especially on motion hearings on temporaries, how many times until I ask at the end, I don't know what it is exactly you want, what parenting type you're looking for. I don't ask that question, I don't know. So make sure you tell me what belief you have and really why you think we should win it. Yeah, a fairly short, concise, so we can get to the rest of that. So organize and target your questions. Cross-examinations, go back to Joel Curring under 10 amendments. So cross-examination, you can short, that's correct question, but ask question or answer to. Many times they seem more like a deposition than that style of cross-examinations. Not that that's inappropriate. There's always times to do that. But it seems like we got to get turned off and use into other things that may be important to the client, but really aren't helpful to me making a determination on what I come to hand right place. Self-representing litigants. Big fan of the limited representation just now. Wow. I think that's been very helpful in divorces on at least getting some advice they can get from a professional as to what this should corporate and what you kick the judge. That these streamlines things so much, as well as the self-help forums that are on the cheap or website. The only real advice I will give to self-representation, had he thought about popping to an attorney and saw that as a limited representation, and he looked at the website, go there, and I'll come back in a week and then we can maybe get addresses. Other than that, I think, I don't know. It seems like self-represented. There seems to be two sides to that. The ones that really don't know anything and know they don't know anything, or just try to muddle through this, and the ones that think they know everything but really don't. And they're really the hardest to deal with because they're pretty insistent that you need to do this. And if you didn't give me the right motion, it's not my jurisdiction to do what you're asking me to do. And so I think the frustrating edge is caught more with those folks than the ones that just want to figure out a way to get through it.
Self-relief vitriol that I prepared.
There's a great movie that just came out with Nick Offerman from Parks and Rec, and he's a sovereign citizen. I highly recommend that. I'm not sure the name of it, but you can IMDb it. Any questions from the audience? Jim? Yeah?
Yeah, you gotta get real close though. Okay. What kind of matter with these to yourself suit in county court cases or federal court cases all for them same stuff over. But crossfield was who have it here, but that's ages moving it. You have any chips or is anybody working on you can rip their ages but is any woods with the pies and kosei yes the
I'm sorry, did you retire that?
How do we deal with vexation? Vexatious?
yes
We're in all different courts, filing all over the place. I'll out to anybody on the panel. Okay. Have any idea of that?
And we've all got those folks from time to time, and the only really do is, premium the way the rules tell you to treat that. They'll then should trip up. Questions how much aim you have to go to before it gets there. But it doesn't matter of those like can't roll an emotion or I can't give you what you're asking is a particular motion because you explain it.
I know that I have had a case that was filed against the Nebraska Humane Society and the Omaha Police Department by a Southern citizen over a dog and possession of the dog, and the lawsuit was for $1 million in a small claims court. And during the course of the argument, I happened to read their complaint and found out that you filed the same thing in federal court for $1 million. So for judicial efficiency, I simply transferred the small claims court to the federal docket because I figured they would kind of I did.
So transfer out like that. Okay.
Sarpy. The report here issued in Florida against Billy Roy Tyler, I don't know if you're familiar with Billy Roy, that he could only file a certain number of lawsuits in federal court. I don't know if they charged him with veritry. I don't remember, but he was limited to like 2 a month. But he filed so many that every once in a while he won, which, the idea of random reinforcement is more enforcing. He continues to file, or till a few years ago, continued to file in the state court.
Well, I think the limit was on the informal pover's file is all he, so about as many as he would have been about.
Oh, I thought it was he could only file 3 cases.
We do have the ability in bar courts. If somebody asks for photo poppers, we can reject it. Everybody lawsuits built so proud stays.
That's the same in Dutch catters. And in Calvin Crew also.
Any others, or we will go or last? Sarah, was that those a no's? Okay. All right. Last but not least, Judge Keane has given some great advice to new attorneys on their walk through the courts over the years, and she's graciously batted cleanup here last, and she's heard everything, so everything good's been taken. Yeah. So this,
Done. Joe, but thank you. I am Molly Keane. I'm a district court judge here in Douglas County.
Oh, you're off on the mic.
District. Hopefully you heard that part. But yes, I mean, a lot of what I had noted and was planning to say has already been cited by my colleagues here. So I'll try to be quick and wrap this up and get you out of here on your Friday afternoon. Generally, I think when I was asked to present here today and think about these sorts of ideas and tips to give, the top things that come to my mind are being conscientious of the court's time. So that involves a lot of things. In district court, we have so many cases that we're trying to hear with substantial issues. So our time is limited. We have, in Douglas County, I think averages between 400 and 500 cases per district court judge. So we're busy, but we want to hear everything. So when we schedule a hearing, be on time for the hearing. Just elementary things. If you're not going to be on time, please contact the bailiff. Just giving them a heads up. Hey, I'm running late, or I'm not going to make it until whatever time, allows us to know that rather than sit around waiting and wasting court time, which is a precious commodity. When you get to court, prepared. I am a new enough judge that I remember being a trial attorney, being in court or hearings, and the running around that you're doing and all of that. But the more prepared you can be, the more efficient it will be, and the better results you'll get for your client. If you are contacting the bailiff for a hearing date or time, because in Douglas County, if you're filing a motion, you have to have the notice of hearing date with that motion. So you have to contact our bailiffs to get the hearing date ahead of time. If you're doing that, make sure you know a few things while you're looking for that time. How much court time are you going to need in order to have your hearing? How far out do you want the case set? Those kinds of things. And then if the bailiff gives you a few options, make sure that you get back in contact with her or him and let them know which date works. Confirm the date that you're going to be taking. Because I think common misconception is that we a notice of every motion you file or basically anything you file. We don't. We only get notice as a judge. I get an email if a brief is can you file. Otherwise, I'm not getting notice that any particular motion was filed. And so don't assume that we know that you have filed a motion, that you are taking that court time that was offered to you. Just get in touch with the bailiff, let her or him know that's the date that's going to work for us, and we'll take that time so that she doesn't have it set aside for no purpose that you're not going to use, or so she doesn't give it away to someone else, she or he. And on that similar note, if you already have a hearing set with the court, and with me in particular, I do a lot of status hearings that are just 15-minute check-ins, basically, to see what's going on and what the next steps are in a case. Don't assume that you can file whatever motions you want to file and set them on that date and time, because chances are we won't have time to get to those motions. So call us and give us a heads up. I have some motions I need to file. When would be a good time? Or, yeah, I think we can get it done in that 15 minutes. Just let us know so we know what to expect at those hearings. Just like we expect and want you to be prepared, I want to be as prepared for a hearing as I can be too. So, like I said, we do get notice of briefs being filed, and that's helpful. But we don't know about motions that you file until we happen to come across it. Like Judge Smith said, maybe looking in the file to review for that 15-minute status hearing, and we say, oh, there's a motion to compel discovery. There's a motion, or whatever it might be, that we need to look at. And on that same note of the opinion that came out this morning regarding progression orders and deadlines, follow those orders, follow those progression orders. When I was talking to some fellow judges today about that case in particular, we all noted those progression orders, they're not dates we came up with generally. They're dates that you as counsel have agreed upon with each other in terms of when you will get things in and what the deadlines will be. So we're there to enforce those days, but we haven't imposed them on you most of the time. So be aware of those dates and follow the progression orders that you've come up with. If you need an extension, reach out to us, let us know. Most of us are going to be amenable to that. And a lot of times what we'll see is the attorneys have been able to work out an extension together, and that's great. That's what we want to see. But maybe it may be in everyone's best interest that you then submit a preparator collecting those amendments so that it's in the record exactly what those deadlines are. Trial orders, those are dates we impose. Make sure you comply with those, because that's another way that you could be excluded from providing and presenting your entire case and all of the exhibits that you need. Our trial orders particularly outline when exhibits are due, when there should be exchange, when they should be into the court reporter, what needs to be given to the court reporter, and witness lists, all of those things. So make sure that you comply with those trial orders so that when you get to trial, you can present the case if you want to present there with the exhibits that you want to use. And on that same line, as Judge Smith was saying with respect to technology, if you're coming in for a jury trial to one of our courtrooms, make sure you understand how you're going to use the technomic in the courtroom to present your evidence. And if that means, and the iPads, this happened many, many times, and it's great, I welcome this. Contact the bailiff, contact the court reporter, figure out a time before your jury trial that you can come into the courtroom and make sure you know how the system works and how to present your particular exhibits that you want to use. We are more than open to that. We encourage that, because then when we get into a trial with the jury sitting there, we don't all look like fools sitting there looking at a screen hoping something pops up and wasting a big issue. Summary judgment orders. It sounds like it works a little differently maybe in Sarpy County because, like I said, you have to have that motion date before you file a motion here in Douglas County. But then our court, I know we filed then a briefing schedule to go along with the summary judgment motion. And again, just make sure you follow those scheduling deadlines. And then the next general topic I had was just be respectful and professional. Everyone has kind of addressed that. This is a career. It's not a one case shot that you're taking here. You are building your reputation over your entire time that you spend practicing law. Don't ruin it with one case or with a fight over one issue that you don't want to rise to that level. These are lawyers that you're going to be working with time and time and time again. So build those relationships as well. Like they all said, talk to each other, communicate with each other. Communication is another big key, I think, to being successful in district court. Speak with opposing counsel. Be respectful of everyone in the courtroom. Be respectful of the judge, but also be respectful to opposing counsel, to the bailiffs, to the court recorders, to the witnesses. We see all of that. We see how you treat each other, how you treat witnesses, how you treat everyone involved in the court. And courtroom demeanor can be important. With respect to bailiffs, they are the gatekeepers of our schedules, so be nice to them. And they will always, regardless, they will always do their best to get you in as timely manner as they can. But if you've built a relationship with them, maybe they'd be able to squeeze you into that little 15-minute slot that's open right now. So don't be disrespectful to them. Don't throw them aside like they're unimportant. They're very important. Pam is my schedule. She's the one who does it all, keeps me in court all day, every day. But hopefully that helps you be able to get in time with us when you need it. Be familiar with the court rules and the amended rules of discovery. All of that is crucial in family law cases. One of the things in Douglas County District Court that's more recent is that mediation is required before filing an application for contempt or complaint to modify on family law cases. And a lot of our judges, if that's not fled in those pleadings, that you attempted mediation, that you've done mediation, that you've attempted mediation, or that you can't do mediation for some specific purpose, a lot of our judges will dismiss those before doing anything with them. Can I skip over a few things there? Generally, I would just say it's be open to understanding that you don't know everything. I can tell you, I have been a judge not that long, but about 4 years now. There are things I've learned. There are things I know. There are so many things I don't know. But I think being able to acknowledge that you don't know everything, but you're open to figuring it out, is very important, not only for a judge, but also for the attorneys. And as attorneys, recognize that we have a lot of new judges in Douglas County District Court, newer judges. And we all want to make the right decision. We didn't come into this thinking, man, I hope I'm just going to impose my will on these cases now. I want to make the right decisions, but I rely on the attorneys to give me the information I need to make those decisions. So take that opportunity in briefs. I will read your briefs before your hearing is at all possible. If there is a reason I can't, I'll tell you I haven't had a chance to read it, but I'll read it after the hearing. But most times I really read your brief before that hearing because I want to understand the issues that you're discussing, that we're arguing, and the basis for your arguments. So take that opportunity to brief those. Let me know. Take that opportunity to educate the judges on issues maybe they don't have a lot of experience with. Because we're open to it. We want to make the right fit. We just need your help to get there sometimes. And I guess on that line, I'll weave into technology a little bit. AI, it's coming, it's happening, it's something we're all going to need to figure out how to work with. I can tell you, district court in the 4th Judicial District is going to be amending our local rules to include a rule about AI and about any pleadings or filings or briefs to the court. You'll be expected to certify one way or another whether you have used AI in preparation of that attachment or not. And we know people are going to use AI. It's just a matter of certifying to the court, yes, I have.
And not only that I used it, but after I used it,
I checked it to make sure that the cases I'm citing to you, Judge, to the court, actually stand for what they're saying and are accurate cases, because AI will hallucinate me, create cases that don't exist, or kind of miss the point of some cases. So you're going to be required eventually to certify whether or not you have used AI, and that if you used it, you checked it. This is your work, and you stand behind what's in these documents. And even before that rule goes into place, here are all officers of the court. You're expected to stand behind what's in your documents you present to the court. And so make sure that the information you're giving to the court is accurate and reliable. Because I think AI is it's coming. We understand people are going to use it. And it can be a great tool, just like most technology, but it also can be dangerous. So use it in ways that benefit us all, not in ways that are deceitful to the poor. That's what we don't want to see.
That's kind of like that.
Judge, one thing that Judge Elliott told me and wanted me to talk about here quickly is there was a 4-day jury trial set, and the counsel the Friday before at about 4 o'clock decided that they were okay with let's move it back. Let's we're gonna push this trial out. They called the court at 4:25 Friday before. Nobody was there. They sent Hail Mary emails, which were read over the weekend, and they did, but they didn't understand that the court has to actually agree to that extension. And they because they agreed to it, they thought, oh, there's no problem. But that's not necessarily the case. You have to have the order in the court. And so that's always good to know that it's not pushed out until there's orders in the court on that.
right, a motion to continue is just a motion. It's not an order. So, yes, I would back that up. And with jury trials especially, there's so much maneuvering behind the scenes that's going on.
an expense that doesn't get canceled in a timely way. So with everything, I think the more heads up you can give us, the better, and the more likely you are to get the outcome that you're hoping for.
Any other questions? But that wasn't a question, that was a statement by the attorney. Any questions? What skips here any longer? Come on. It's 1 billion degrees outside. Y'all want to go outside. All right. Well, thank you, judges. Thank you so much.